That's Preston.
Oh, okay, Preston can, yeah.
He's a better prayer than I am.
Well, I don't know about that.
The roof might fall.
I wish.
Your brother's preacher.
Well, I got the black sheep jeans.
Oh, you did?
Yeah, both the other two brothers got all
Good genes?
the good jeans.
Would you lead us in the pledge, please?
Yes, sir.
All right, call the meeting to order. Stand, we'll have a pledge and a prayer.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Bow our heads, please. Most gracious Heavenly Father, we do thank you for this day and your blessings, Lord, for so many. And Father, we just thank you for this meeting. Just go into it, Father, with open minds. And thank you for the people that showed up, Heavenly Father, whoever's speaking, that do what's best for the county. And let's go with us down in this meeting and lead us, guys, and direct us. In Jesus' name we pray. Amen.
Amen. All right, approval of the agenda. There is one minor altercation. We're going to table the memorandum of understanding, Washington County Fair Board and Washington County. I need a motion to that effect.
Make that motion.
Okay, second. All those in favor say aye.
Aye.
All right. Other than that, do you have any changes to the agenda, Mr. Cardwell?
No, sir.
All right, need a motion to approve the agenda.
Make that motion.
I'll second that. All those in favor say aye.
Aye.
Thank you. All right. Max Greene, come forward, please.
I was really hoping to send the third commissioner here, so it might make a difference, but I might go ahead and present anyway. The public hearing on the ordinance, best I can tell, did not meet the state requirements under IC 5-14-115-2.9, which requires that they comply with section 2. The governing body shall include the website of the live stream transmission, archived copies, and live stream transmissions for all the meetings and the meeting notices. That's from the state of Indiana. And that's also, it has section E where the governing body may record instead of if they do not have live internet capacity, which some of the boards actually have live streaming capacity and still haven't been compliant with the state law yet, and it's been in effect since July. I'm gonna say that the failure to comply with this having legal notice is what cost the court to overturn the county in the Turner case just last year, because Judge Medlock decided that they couldn't have the 60-foot setback because they couldn't prove they had a legal notification to the public. I'm saying it appears that you're just opening up for the same thing all over again. The new ordinance for Washington County subdivision control ordinance is to replace the old ordinance, which is in effect from May 2011. The problem with the new ordinance, it does not meet the legal requirements under Indiana Code 36-7-4-702. that which requires a minimum width, depth, and lot area, public ways, width, grades, curves, and coordination of subdivision, public ways with the current and planned public ways, and the extension of water, sewer, and municipal services. The old ordinance, which the county has right now in effect, has all that was written out. It has the grades and the curves and everything that was required. It has the lots, width, depth, and everything that's required under state law, but the new one doesn't have that. I'm asking it to go back to the committee and actually become, take the new ideas and combine with the old one, which is actually legal at this time, instead of replacing it with a new ordinance that does not comply with state law. And in saying that also, that we have we have 3 commissioners in the county. One of them who's actually sitting on the board right now doesn't own or reside within the jurisdiction of the board, doesn't have the skin in the game. I think that the other commissioners, one who actually does have skin in the game, should be considered to be put on this planning board when it goes back to be reevaluated and written in a proper way for the public. That's not saying that the commissioner doesn't have the ability and authority to serve on that board, but it's the rest of the citizen members have to reside or in the jurisdiction of the board and abide by the same rules where in a 2-mile fringe they have, for instance, a 1,500-foot setback from confined feeding operations, where out in the county it's only 400 feet.
Okay.
I think they should provide with the same statutes that the rest of the county does on anything they go forward with.
Okay, thank you, Max. You're over your time. Thank you.
No, I'm giving him my time, so he.
Okay.
I'm good.
Okay. However you want to do it.
Do you want to talk about your time?
Oh, no, I'm good. I'm good.
Okay, Rhonda, you're up next.
No, I gave my time to him. He wasn't over.
Can I take your time?
Yeah, please take my time, yeah.
Oh.
Whatever's left, yeah.
You can't do, I don't think you can do that.
I don't
You-
think Max used
you-
to take her time, so it was
you-
never subdivided.
You and Max can, but go, come ahead. Morning.
Good morning, Todd. Good morning, Tony. I'm sorry to see Phil's not here, so I hope you all keep him in our thoughts and prayers. Because he's got some rough roads to handle. So I coming before us this morning to talk about a subdivision plan, and I sit on the planning commission. I voted against the subdivision the way it is currently sitting for a number of reasons. There are a number of anomalies that are in the current subdivision plan that has been proposed, and contradictions. For example, in the administrative section on page 4, it says that the section shall provide procedures including less than 5 parcels, including the parent tract. So less than 5, by definition, would be 4, 3, 2, or 1, including the parent tract. But yet, when we go just a few sentences down to applicability, it says the division of land into no more than 5 parcels, including the remainder of the parent at least 1. So here we have one that's an internal contradiction there. If we go to the minor subdivision, it has something which I think is kind of similar. There it is, minor subdivision. So the section shall provide procedures for subdivisions that include more than 5, but no more than 8. So that would be by definition 6, 7, and 8, because it has to be more than 5. But when we go back to the minor subdivision, it said that it had to be less than 5. So we literally have a situation where the administrative says it has to be 4, 3, 2, or 1, and then the minor says it has to be 6, 7, or 8. So we literally don't have a plan for somebody having 5, which is kind of weird. I didn't catch that during the planning commission when we were looking at that, so that's something that we need to catch, is looking for more of those anomalies. Another thing that I think is really unfair and not well thought out is that there's a rule in there that there would be no more than 3 parcels per easement. And that really restricts the ability to subdivide property in such a way that is useful to the people who are using it. And the whole point of this is to have guidelines so that people can have their property divided in a way that works for them. And by putting these kind of restrictions on there ahead of having an actual situation where we can see how that actually applies, well, we're putting ourselves in a situation that might affect you later. As I talked about at the Plan Commission with regards to surveys, letter H says under minor that plot plans prepared by a surveyor must be submitted. Right now, if I had, 100 acres, I could just put a line right through the middle of it, and I could, bring that, and they would take that line that's written on a piece of paper. I wouldn't have to go and have a survey done for thousands and thousands of dollars. The thing that I'd like to see most in this is the removal of the number of parcels that things are subdivided into, and because there's really very little difference between the less than 5, more than 5, leaving number 5 working, and a complete and utter exemption and waiver for families that are dividing. No family should be affected by this.
Time's up, thank you. We will take all these things under advisement. I've spoken to Mr. Cardwell about one in particular. Appreciate that. Thank you for your time. All right, meeting minutes from the October 7th meeting.
I make a motion to approve the minutes of October 7th meeting.
Yeah, thank you. I'll second that. All those in favor say aye.
Aye.
Claims and payroll.
Yeah, I'd still like to know what that one company does for us. They do a variety of things. I was just curious. The Baker Tilly.
Oh,
They do a variety of things. So I'm just curious what that goes.
well,
They helped with bonding on whenever we built the jail, any construction projects, anything to do with whenever we had the ARP money, CARES Act money, they are.
Take care of the bonding issue for us then. Is that
well,
In the past,
in audits, the ARP money, there's dozens and dozens of things that they provide services for and have for many years.
I make a motion to accept the
Okay,
approve the claims.
okay. I'll second that. All those in favor say aye.
Aye.
All right. Aaron Schelhammer with I believe Tyler and Sherry, come forward, please. Good morning.
Good morning. How are you?
We're all right.
Good. It's going to be time, it's now time to do our reassessment contract.
Yep.
I ran all the ads for requesting bids. No one else placed any bids. And so we have Tyler Tech's bid in place. I shared a copy with Kyra and a copy of the contract as well. And would like to submit that for approval, and Aaron is here to answer any questions that you may have.
Okay, I've not had an opportunity to read through it. Are there any changes from the previous year? I know you guys, this is pretty much all you do. You've done us a good job over the years. Now, you're pretty salty, but when somebody does the kind of work you do, it requires some expertise. And you guys have always been there for us. I know anytime that I would stop in when you're here in the courthouse and ask a question, you've been very helpful, and you know your stuff, and I just would like to know if there are any changes to the previous contract.
I don't believe there are. I think it's essentially the same services as before.
And what was the amount of that annual contract?
Page 10 of 22. Out here.
I believe it was
48,730 for the second 4 years.
248,730.
Yeah, 248,730, but that is for
4 years.
for 4 years.
Yes.
Yes. Okay. Just for the benefit of the taxpayers and community and everyone, could you just briefly tell us what you do for the county and how important it is? Because basically, you are in charge of making sure that the county receives the correct income.
Yeah,
Right.
So we review all the commercial and industrial properties and utility properties for the county. We also do the annual ratio study, which determines the overall value of the properties every year. We do a land order that determines the land values. All that kind of rolls up into the overall value. And we have to follow the DLGF guidelines on that every year, so we're kind of governed within where we can work. But essentially, that's what kind of what we do.
Being asked to be before your microphone.
Oh, is that better?
Okay.
They keep us within our guidelines that we have to meet and keep us in compliance. And
Right.
I would like to point out that the price that or the fee amount is less than what we had anticipated, and it is less than what we have been paying.
Okay, great.
I saved you money.
That's what we like to hear. That's part of your job.
I try.
You know you do.
So you basically do the assessment for our property taxes.
Yeah, we do. You have to do 25% of the county every year. So the county handles the res and ag section of that and exempt properties, and we handle the rest. And then on top of that, of course, you do, an annual ratio study that has to be submitted to the state, and that in essence determines what the values are. You have to submit that, it goes through an approval process at that point.
You said 25% a year, do you pick a section or is it random?
It's pretty well set out. We initially set that up kind of by township, but the state gets very strict in their 25%. So we're allowed a 2% variance either way of that. So sometimes we have to dip into another section to meet that requirement. But for the most part, it's initially set up on certain townships during that period of time.
And they can't, the state can change where they want us to go.
Excuse me.
We still reassess every year.
Yeah.
Yeah, if you were to fall out of line of what the DLGF specifications were for a ratio study, they could request you go in and reassess that area. But usually if you're within their statistical analysis parameters, you're okay. They won't step in there. They want that local control given to the county. They don't want to step in, but there has been cases in the past in counties where they have.
All right. You have any other questions?
No, I appreciate the education. I'm sure the public does too.
Yeah, anytime you guys have any questions on kind of what we do, feel free to stop in.
Yep.
We'll kind of show you the inner workings.
Well, thank you. Appreciate it. I need a motion to approve the Tyler contract.
Make that motion.
I'll second that. All those in favor say aye.
Aye.
Aye. Good to go.
Thank you very much.
Thank you. All right. First reading of the subdivision control ordinance. And was Lisa going to do that? Or? I think so.
I don't know.
Lisa, did you want to zip through that for us?
And it's just first reading, so we're not gonna vote today.
No, yeah. Good morning.
Okay. We start with a table of contents, and I'll just briefly go through that, so you know what's coming. Under subdivision control, there's classifications and general provisions and discussion of preparation of subdivision plats, and then there's a section on subdivision authority. And then we get into the three sections which deal with, first off, the administrative subdivision, the minor subdivision, and the major subdivision, and then there's the certificates and notations pages. So I'm gonna go pretty quickly. If I go too quickly, you all stop me. Subdivision control. This ordinance shall establish regulations pertaining to the division of land in Washington County pursuant to the comprehensive plan for the orderly, planned, efficient, and economical development of the county. Any prior ordinances pertaining to subdivision control and amendments thereto are hereby amended and repealed. Land to be subdivided shall be of such character that can be used safely for building purposes without danger to health or peril from fire, flood, or other menace. It's hard to say. Menace. Land shall not be subdivided until adequate infrastructure and services exist or are guaranteed in accordance with this ordinance, and proper provisions have been made for drainage, water, sewage, and public facilities such as parks, recreational facilities, streets, and sidewalks. Private wells and septic systems in lieu of public water and sewer facilities are allowable where approved by the Washington County Health Department pursuant to Indiana Code 13-18-12 and 410 Indiana Administrative Code 6-8-3 and 410 Indiana Administrative Code 6-10. All wells and septic systems must conform to state regulations set forth by the Indiana Department of Environmental Management, also known as IDEM, and the State Board of Health. Subdivision of land shall fall within one of three classifications of land divisions. When determining which class of subdivision the proposed development falls within, the applicant or agent shall refer to the materials that follow in this ordinance before submitting any of the materials required. So again, the subdivision classifications are administrative, minor, and major subdivisions. And the general provisions are that no parcel shall be created upon the adoption of this ordinance without the approval of the Washington County Surveyor. Any division of a parcel of land must be compliant with this ordinance. And no proposed parcel shall be advertised as for sale or constructed upon until the Washington County Surveyor has approved the subdivision plat. No parcel or remainder thereof shall be rendered landlocked as a result of the subdivision. Residential structures to be erected on a parcel created prior to the passage of this ordinance that does not meet the prescribed minimum shall be deemed legal nonconforming and may be issued a building permit with proof of the dated record deed and approval from the Washington County Health Department unless connection to a municipal sewage system is available. Preparation of subdivision plats. All subdivision of land shall be accompanied by a plat prepared by a professional land surveyor licensed in accordance with the laws of the state of Indiana. All surveys and plats shall be in accordance with 865 of the Indiana Administrative Code 1-12 and any amendments thereto. All plats shall be no larger than 24 inches by 36 inches. Subdivision authority. The Washington County Commissioner shall adopt the subdivision control ordinance and any amendments thereto. The county commissioner shall accept appropriate performance guarantees and maintenance guarantees and shall take such actions as necessary to enforce the terms of those guarantees pursuant to Indiana Code 36-7-4-709. The county commissioner shall accept dedications of rights of way or public improvements on behalf of Washington County. In accordance with Indiana Code 36-7-4-701B, After the subdivision control ordinance is adopted and a certified copy of the ordinance has been filed with the county recorder, the Plan Commission has exclusive control over the approval of all plats and replats involving land covered by the subdivision control ordinance, subject to subsection C and F of Indiana Code 36-7-4-701. In accordance with Indiana Code 36-7-4-704, the Plan Commission shall adopt a schedule of fees for the review and approval of subdivision plats. In accordance with Indiana Code 36-7-4-705 and Indiana Code 36-7-4-707, the Plan Commission shall establish procedures for holding hearings and for maintaining accurate records of its proceedings. In accordance with Indiana Code 36-7-4-701E, the County Plan Commission may appoint a plat committee to hold hearings on and approve plats and replats on behalf of the Commission. The Planning Committee is authorized to grant primary approval without notice or hearing of a minor subdivision that complies in all respects with the standards of this ordinance, subject to the right to appeal to the Planning Commission. The Planning Committee shall keep accurate records of its proceedings and shall operate in accordance with the Planning Commission's rules of procedure. The Planning Commission may appoint a technical review committee at their discretion to assist with the technical review of proposed subdivisions. The Technical Review Committee may make recommendations at the discretion of the Planning Commission. Administrative subdivisions. This section shall provide procedures for subdivisions that include less than 5 parcels, including the parent tract, changes in existing parcel lines, and proposed utility and access easements. These subdivisions do not substantially affect the comprehensive plan, require new or the extension of public roads or utilities, and are exempt from the approval of the Planning Commission or Planning Committee. Applicability. This section shall apply to the following proposed subdivisions. The division of land into no more than 5 parcels, including the remainder of the parent tract of at least 1 acre. The proposed subdivision shall not include any new streets, public or private. Each parcel shall have a minimum of 50 feet of deeded access to be deemed a residential building tract. Each parcel shall have a minimum width of 150 feet measured at the front building line. Tracts exceeding 10 acres are exempt and are not included in the 5-acre parcel, including the remainder maximum requirement. Newly created parcels accessed exclusively by easement shall be labeled as non-residential building tracts, and the subject easement shall be labeled as agricultural or recreational access easement. A plot plan prepared by a surveyor shall be included with any subdivision proposal, and the plot plan shall include all features described in items A through E above, and shall comply with the requirements of the International Code Council, International Residential Code 2018 R106.2. The subdivision shall not be detrimental to nor endanger the public health, safety, or general welfare. Transfer areas. When a landowner is purchasing property from an adjoining landowner that an existing parcel will encompass, the transfer shall be deemed an administrative subdivision. The subject transfer area shall be labeled as such and hatched. This is to denote the intent of the plat. This parcel shall not be sold or transferred as a residential building tract unless adequate access, acreage, and frontage are provided. Replat. Parcel replats limited to the following circumstances: the removal or relocation of an existing parcel line resulting in no more parcels than originally planted, the changing of a notation described on the plat in error, the subdivision of land pursuant to an allocation of land by court decree, the subdivision of land for the acquisition by the public or by a utility for right-of-way or easement, the division of land into cemetery plots for the burial of corpses. Standards. All proposed administrative subdivisions shall be submitted with a plat and a meets and bounds legal description prepared and certified by a licensed land surveyor and in conformance with the survey standards set forth in 865 Indiana Administrative Code 1-12. Approval and recording. Administrative subdivisions shall be submitted to the Washington County Surveyor for review and approval. The Washington County Recorder shall not accept or record an administrative subdivision unless it carries the stamp and approval of the Washington County Surveyor. Access. All parcels shall have driveway locations that shall provide for adequate site distance and space according to the Washington County Highway Department and/or the Indiana Department of Transportation standards. Okay, we're moving on to minor subdivision. This section shall provide procedures for subdivisions that include more than 5, including the parent tract, and no more than 8 parcels. These subdivisions do not substantially affect the comprehensive plan, require new or the extension of public roads or public utilities, and shall be approved by the planning committee. After a subdivision request has been filed, the Washington County Surveyor shall determine whether the petition may be considered as a minor subdivision. The Washington County Surveyor's decision may be appealed to the Plan Commission. Applicability. This section shall apply to the following proposed subdivisions: the division of land into more than 5, including the parent tract, and no more than 8 parcels of at least 1 acre. Each parcel shall have a minimum width of 150 feet measured at the front building line. Parcels exceeding 10 acres are exempt and are not included in the 8th parcel, including the remainder maximum requirement. The subdivision shall not impede the orderly development of land or the provision of public services and improvements. The subdivision shall not interfere with the implementation of the comprehensive plan. The subdivision shall not interfere with the provision of roads to provide access to adjoining or nearby property in the event that such property is developed in the future. All parcels in the subdivision shall have adequate utilities and drainage. A plot plan prepared by a surveyor shall be included with any subdivision proposal, and the plot plan shall include all features described in items A through G above, and shall comply with the requirements in the IRC 2018 R106.2, and that's the International Residential Code. The subdivision shall not be detrimental to nor endanger the public health, safety, or general welfare. Access. All proposed parcels shall have adequate ingress and egress without the construction of new streets, public or private, or extension of existing roads. The proposed subdivision shall not include access easements for residential building tracts unless approved by the planning committee. The planning committee shall not approve residential access easements unless all other options have been exhausted and the planning committee determines that it can be used safely for building purposes without danger to health or peril from fire, flood, or other menace, and adequate infrastructure exists. All access easements shall be a minimum of 50 feet wide. For all common access easements, a written maintenance agreement shall be submitted and recorded with all landowners who have a shared interest in the proposed easement. In no case shall more than 3 parcels be accessed by an access easement. All parcels shall have driveway locations that provide for adequate site distance and space according to the Washington County Highway Department and/or the Indiana Department of Transportation standards. Filing. An application for approval of a minor subdivision shall be filed with the Washington County Surveyor. Review process. The Plan Commission hereby establishes a planning committee to review and decide petitions for minor subdivisions. The planning committee process is as follows. Approval. The planning committee shall approve the proposed minor subdivision in accordance with the provisions of this ordinance. Review. The planning committee shall review the proposed plat for compliance with this ordinance. Action. The planning committee action shall be by majority vote. Notice. The planning committee may approve without public notice and hearing. Appeal. Any person aggrieved by a decision of the plat committee may file a notice of appeal with the office of the building commissioner within 10 days of the decision. The Plan Commission shall hear and decide such appeals in accordance with Indiana Code 36-7-4-918.1 through 918.6. Certification. The Planning Committee Chairman and Secretary shall be authorized to sign the approval certificate of the proposed plan. Approval. Primary approval. All applications for primary approval of a subdivision shall be submitted with the following: a primary plat, an original plat prepared by a registered and licensed surveyor in accordance with the following standards, to include a legal description or descriptions, parcel numbers, dimensions, and size in acreage or square feet. Boundary lines of any special flood hazard area should be appropriately labeled if applicable. Any existing or proposed easements, including but not limited to access, drainage, and utility. Any public right-of-way. And this ordinance requires all applicable certificates or notations. Final approval. After all conditions of primary approval have been met, the applicant may request final approval. If the planning committee has no amendments and primary approval is granted, final approval may be granted immediately at the discretion of the committee. Length of approval. Primary approval shall be valid for 1 calendar year unless the planning committee grants an extension. If the plat is not recorded within 1 year of final approval, the final approval shall be null and void. Filing fee. Minor subdivision applications shall be accompanied by the required filing fee as established by the County Planning Commission. Recorded. The approved plat must be recorded with the Washington County Recorder within 1 year of the plat, or the plat shall be null and void. Okay, we're moving on now to major subdivisions. This section shall provide procedures for subdivisions that do not meet the requirements set forth in the administrative and minor subdivision sections and or require the extension of roads, utilities, and other infrastructure elements. Major subdivisions require a public hearing as well as primary and secondary approval in accordance with the procedures set forth in the Plan Commission's Rules of Procedure. Applicability. This section shall apply to all major subdivisions. Each parcel shall be a minimum of 1 acre. Each parcel shall have a minimum width of 150 feet measured at the front building line. The subdivision shall not impede the orderly development of land or the provision of public services and improvements. The subdivision shall not interfere with the implementation of the comprehensive plan. The subdivision shall not interfere with the provision of roads to provide access to adjoining or nearby property in the event that such property is developed in the future. All parcels in the subdivision will have adequate utilities and drainage. A plot plan prepared by a surveyor shall be included with any subdivision proposal, and the plot plan shall include all features described in items A through G above and shall comply with the requirement of IRC 2018 R106.2. The subdivision shall not be detrimental to nor endanger the public health, safety, or general welfare. Streets and access. All proposed parcels shall have adequate ingress and egress to new or existing roads. The proposed subdivision shall not include access easements for residential building tracts unless approved by the Plan Commission. The Plan Commission shall not approve residential access easements unless all other options have been exhausted, and the Plan Commission determines that it can be used safely for building purposes without danger to health or peril from fire, flood, or other menace, and adequate infrastructure exists. All access easements shall be a minimum of 50 feet wide. No more than 3 parcels shall be accessed by 1 access easement. For all common access easements, a written maintenance agreement shall be submitted and recorded with all landowners who have a shared interest in the proposed easement. All parcels shall have driveway locations that provide for adequate site distance and space according to the Washington County Highway Department and or the Indiana Department of Transportation standards. All streets shall include street signage according to the current edition of the Manual on Uniform Traffic Control Devices for Streets and Highways, as published by the U.S. Department of Transportation Federal Highway Administration. Where the proposed street will have less than 400 AADT and shall be classified as a local street, the signage may follow the requirements for low-volume roads in the manual. Street name signs shall be placed at all street intersections. Local subdivision streets may use a 4-inch minimum letter height, but street name signs along collector roads or rural roads must follow the MUTCD standards with a 6-inch minimum height. Utility and drainage easements. Easement locations and widths must be coordinated with utility companies to ensure that the needs of each utility are met. Easements must maintain a minimum width of 10 feet when located adjacent and parallel to the street right-of-way. When easements are not along streets, a minimum width of 16 feet shall be provided. When located along parcel lines, the easement may be half on each side of the parcel line. Filing process and approval procedures. An application for approval of a major subdivision shall be filed with the Washington County Building Commissioner. The following review process shall be followed when considering a major subdivision. Conceptual plan review procedure. Upon the filing of an application, the applicant shall be placed on the Plan Commission agenda for consideration at their next regularly scheduled meeting. Prior to the Plan Commission meeting, the Building Commissioner shall review the conceptual plan. The Plan Commission shall review the proposed conceptual plan at a public meeting. The Building Commissioner will present comments on the proposed subdivision at this time. The Commission will discuss the proposed subdivision and guide the applicant as to the suitability and feasibility of the proposed design and layout. The Commission shall, by motion duly made and seconded, approve, deny, or continue the conceptual plan. The Plan Commission will provide a written record to the applicant of the discussion within 30 days after the meeting at which the proposed conceptual plan was discussed. Primary approval procedure. After receiving the written record from the conceptual plan review, the applicant may apply for primary approval with the Washington County Building Commissioner. Upon applying, the applicant shall be placed on the Plan Commission agenda for consideration at their next regularly scheduled meeting. Prior to the Plan Commission meeting, the Building Commissioner shall review the primary subdivision plan. The Plan Commission and its representatives, at its discretion, may visit the proposed site during the review process in accordance with Indiana's open door law. The Plan Commission shall review the proposed primary subdivision plan at a public hearing. Public notice shall be published in accordance with Indiana Code 5-3-1 and sent in compliance with the Plan Commission's rules of procedure in accordance with Indiana Code 5-3-1-2B and Indiana Code 36-7-4-604. The applicant shall present to the Plan Commission at the public hearing, and the Plan Commission shall make a decision regarding the application. The Plan Commission shall make findings of fact in compliance with the subdivision application. The Plan Commission shall by motion duly made and seconded approve, deny, or continue the application. If the Plan Commission denies the application, it shall provide written findings that set forth the reasoning, and the building commissioner shall sign the decision and provide the applicant with a copy within 30 days after the public hearing. If the Plan Commission grants primary approval, 2 Plan Commission officers shall sign the primary certificate. Secondary approval procedure. After the conditions of primary approval have been met, the applicant may apply for secondary approval with the Washington County Building Commissioner. The Building Commissioner shall review the secondary plat to determine if it is compliant with the primary approval conditions. If the subdivision plat varies from the primary approval and conditions, the subdivision will not receive secondary approval. Deviation from the primary approval must be submitted and approved by the Planning Commission. Subdivisions, including public improvements or dedication of right-of-way, shall require acceptance by the Board of Commissioners and must be installed in accordance with the approved plans. Guarantees of performance shall be required as specified in this ordinance. Upon secondary approval by the Building Commissioner, acceptance of the Board of Commissioners, and submittal of all guarantees of performance, the Building Commissioner shall sign the proposed plan as approved. The secondary plat must be recorded with the Washington County Recorder within 1 year of secondary approval, or the plat shall be null and void. Conceptual plan review. Before filing a major subdivision, applicants are required to present the conceptual plan for the proposed subdivision to the Plan Commission for approval. In order to assist the applicant in preparing an acceptable major subdivision proposal, the Plan Commission shall review and discuss the conceptual plan with the applicant and/or his or her representatives. The purpose of this discussion is to enable the applicant to receive guidance from the Plan Commission as to the suitability of the land for the development proposed and as to the pattern of development the Plan Commission considers to be in the best interest of the county. Accurate surveys and detailed engineering data are not required nor recommended at this stage in the subdivision process. Required conceptual plan materials. All applications for conceptual plan review shall be accompanied by the materials listed in this section: a north arrow and date, approximate site boundary of proposed subdivision, existing zoning classification, existing county or state roads that will serve the proposed subdivision, general soil classifications and drainage patterns, existing features of the site including streams, ponds, floodplains, wooded areas or structures, all existing utilities and utilities that will be serving the proposed subdivision, proposed street layout, proposed parcel layout, any areas designated for open space or common areas including retention areas, proposed subdivision name. Applicants shall verify with the Washington County Surveyor that the proposed name of the subdivision does not exist. Plan Commission approval. Conceptual plan approval shall be valid for a period of 1 calendar year from approval. If the applicant fails to apply for primary approval within 1 year, the subject conceptual plan approval shall be null and void. Prior to guiding the applicant, the Plan Commission shall consider the following: subdivision location and layout in relationship to all existing features and topography, traffic patterns and circulation, drainage on site in relationship to adjoining property, utilities including sewage disposal, water, electricity, and other utilities, and how the proposed subdivision aligns with the comprehensive plan. Primary rule review and approval. Upon approval of the conceptual plan, the applicant may request primary approval within 1 calendar year. Filing fee. Major subdivision applications shall be accompanied by the required filing fee as established by the Planning Commission. Required primary approval materials. All applications for primary review shall be accompanied by the materials listed in this section: parcel numbers, dimensions, and size of acreage or square feet, existing and platted streets intersecting or within the proposed subdivision boundary, The existing property lines, including interior lines, if to be vacated, and the current owner's title is to be vacated per the Washington County Recorder. Boundary lines of any special flood hazard area should be appropriately labeled if applicable. Any existing or proposed easements, including but not limited to access, drainage, utility, etc. Any public rights of way. All applicable certificates or notations required by this ordinance. Topographic contours at vertical intervals of 5 feet are shown on a separate page, but on the same scale as the original plat. Location and size of all existing or proposed permanent features, including but not limited to streets, sewer lines, drains, bodies of water, railroads, transmission lines, legal drains, water mains, culverts, utility lines, hydrants, drainage features, sidewalks, street lights, etc. All streets must meet the required specifications of the Washington County Highway Department. The applicant shall provide documentation from the Washington County Highway Superintendent verifying that all proposed roads and right-of-way meets the specifications required. Delineation of any future subdivision phases if applicable, preliminary erosion control plan, preliminary sewage disposal plan, preliminary drainage plan and report, preliminary plans for improvements to existing county roads if applicable, restrictions and covenants for the proposed subdivision if applicable, and preliminary plan for all improvements or systems that are to be owned and maintained by the property owners in the subdivision, including the establishment and plan for financing subject improvements. Length of primary approval. Primary approval shall be valid for 1 calendar year unless the Washington County Planning Commission grants an extension. If secondary approval is not granted within 1 calendar year of primary approval, the primary approval shall be null and void. Secondary approval. After all conditions of primary approval have been met, the applicant may request secondary approval. Filing fee. Major subdivision applications shall be accompanied by the required filing fee as established by the Plan Commission. Required secondary approval materials. All applications for secondary approval shall be accompanied by the materials listed in this section. A secondary plat. Original drawings prepared by a registered and licensed land surveyor in accordance with the standards set forth in this ordinance, and copies with the number to be specified by the Plan Commission showing all information listed above with computed parcel dimensions and sizes in accordance with the Plan Commission's approval. Final improvement plan detailing all improvements to be installed is approved by the Plan Commission. Supporting documentation. Documentation showing that all conditions of primary approval have been met. Certificates and notations. Surveyor certificate. A surveyor certificate prepared in compliance with 865 of the Indiana Administrative Code, sections 1 through 12, and any amendments thereto shall be included on all plats. Administrative subdivision certificate. An approval certificate for all plats requiring administrative approval shall be on all plats as follows. Administrative subdivision approval. Under authority provided by Indiana Code 36-7-4-701B, subdivision control, and any amendments thereto, this plat was given administrative approval by Washington County, Indiana as followed. And there's a spot there for the date of the approval of the Washington County surveyor and then the surveyor's signature. Primary approval certificate. A primary approval certificate for all plats requiring primary approval shall be on all plats as follows. Under primary approval, under authority provided by Indiana Code 36-7-4-701B, subdivision control, and any amendments thereto, this plat was given primary approval by Washington County, Indiana as follows. Approved by the Washington County Planning Commission or Planning Committee at a meeting held on, and there's a date for the meeting, and a signature that's required from the chairman and the secretary. Improvement plan certificate. An improvement plan certificate for all major subdivisions requiring secondary approval shall be on all plats as follows. Improvement plan. This document contains or is a part of the approved improvement plan for the following subdivision. And there's a spot for the name of the subdivision. The improvements to be installed in the subdivision will not be accepted for maintenance by the County of Washington unless and until all improvements shown herein have been installed and are in substantial compliance with these plans. And there's a spot for the county highway superintendent to sign and then the date of his or her signature. Dedication certificate. A dedication certificate for all major subdivisions requiring secondary approval shall be on plats as follows. County Commissioner's dedication acceptance. Be it resolved by the County Commissioners of Washington County, Indiana, that the dedications shown on this plat are hereby approved and accepted, and there's a spot for the date, and to be signed by the President, Vice President, and member. Private access easement notation. Plats containing private access easements as approved by the Planning Committee or Planning Commission shall include the following notations. This plat contains property shown as private. The property owner shall assume the responsibility for maintenance and snow removal. This is not the responsibility of Washington County. That's it in a nutshell.
Okay, seems like a lot, but actually it's probably one of the shortest subdivision ordinances in the state of Indiana. Week before last, the surveyor randomly went and got online and looked at 8 other counties throughout the state and made a notation of how many pages their subdivision control ordinance was. Fulton County, Indiana is 103 pages. Shelby County, 369. Brown County, 47 pages. Randolph County, 53 pages. Vermilion County, 33 pages. It was adopted in 1970. Franklin County, 193 pages. Park County, 169 pages. And Pulaski County, 255 pages. And ours is 17. So for anyone to make the claim that this is overreaching and extreme, well, it's just not so. This is the bare minimum, and it's a good document. We are going to look at a couple things Mr. Cardwell and I spoke about, area of concern, but I think it's good to go, and we'll move forward, and I thank you for reading it.
Sure, glad to. Thank you.
All right. Health Board reappointment. Is there anybody from the Health Board here? Yes. This is just a reappointment, I understand.
It's a reappointment of Janet Hines, beginning January 1 of 26 and ending December 31st of 29.
Okay. All right, I'll make the motion to reappoint her.
I second that.
Tony seconds. All those in favor say aye.
Aye.
Aye. All right. Mr. Eckert, you can come forward now. Morning.
Good morning. Good morning all. Quick update on the highway garage. Last week Duke finally energized the panel going to the office. So now we have power out there to the office, which will be used to power the sign shed, the fuel station, and the mixed salt buildings. So the electrician working on getting all those all powered up and ready to go. The plumbing in the office will be starting tomorrow. They've already got everything roughed in, now they're in the wall rough, getting it above the floor. They won't install fixtures yet, because we don't want people using the fixtures yet, but they'll get everything ready for fixtures to be installed. If you've been out there, I don't know if you've seen the HVAC, they've ran a bunch of stuff, the ceiling grid. I won't be putting the tile in until everybody's done above the ceiling.
Right.
But the electrician, they'll put his lights in and everything in the office, then we'll put the ceiling tile in. Mixed salt buildings, you can see they're vertical now. They're all, Grader's done a pretty good job getting all them, all siding, sided on the inside, and we're gonna put that, I can't remember what it was, but the salt preventative, panel on the inside to help out the mixed salt buildings. Mechanic shop, well, let me back up. On Duke, they still have not powered the other panel that's going to the truck building, the truck storage building. the way they brought the power in, they have to send their metering guy, to get that remetered appropriately because of how they brought that in. I can't tell you the specifics on that, although I'm just calling them every other day to say, hey, you got that figured out yet. But when they change the power, from underground to the transformer, they need to do something with their metering. So as soon as they get that done, we'll have power to the truck storage building, the mechanic shop. Yeah, those two buildings are fed from that panel. So in the mechanical shop, the framer's been in there. He's put up a lot of the walls. He's left one side open for the plumber. He's got it insulated. The plumber will be there. He's gonna be in office Wednesday. Thursday, he'll be in the mechanic shop, try to do all the wall rough in there. And then we'll get the drywall and siding on it to get that all sealed up. Everything in the mechanic shop on the electrical is all surface mounted, so the electrician will come in after that and do all the surface mounted electrical conduits and lighting. Site concrete, we're out there pouring today on some of the site concrete. Say we're just jumping around, but I think we're pouring on the north side there around the mixed salt building and in that area today. Probably tomorrow also, so we'll just continue on that concrete. And put in more stone on the backside of the mechanics garage, trying to get that entrance built up for going out on Lake Salindo Road. So that's kind of the major highlights.
Okay.
And Todd, I gave that letter to Ken Temple today on the ag bins, so
Good.
he should be reviewing and discussing. I know you all talked about Thursday and Friday
Yeah. Okay.
What's that pertain to?
The aggregate bins. Just
What about it?
about the design, the amounts, all the items that are included in the ag bins.
What, prior to the information, so what just.
Yeah, originally, to get to the 4.8, they took the ag bins out. So this is, if we're gonna add them back in, this is what it takes to add them back in.
All right. Mr. Boyles, do you have any questions for Paul? Okay.
Thank you.
Thank you, Paul.
I do got one. The solution on the asphalt, did we come up with that?
We have discussed all the asphalt with Phil. He's wanting to see how far the original will take us, and if we're gonna try to do a little bit more. We're just trying to define that line. Because originally it was 2,400 tons for a certain area of the blacktop at 5 inches deep. So we're seeing if we want to stretch it to maybe just put a liner in and then surface it next year, or go with 2,400 tons and get as far as we can. So that's still just kind of for debate right now. And Phil and I would talk about that once a week.
Okay.
All right. Thank you.
I guess you didn't call on me, but you gave me a look, so I just came head up.
Oh, I can read your mind.
Be careful, it's scary.
I know it is.
All right, at the last meeting, we opened 3 bids for Bridge 39, and the low bidder was Temple Excavating for $718,225. After reviewing the bids, it would be my recommendation that we award that project to them.
Okay. All right.
I'll make a motion to accept Rick's recommendation.
Thank you. I'll second that. All those in favor say aye.
Aye.
Thank you.
And that's really all I have for you today.
When's that gonna start?
It'll be, in the spring sometime. We're just
Yeah.
getting ahead of it.
Yeah, when the water goes down, right?
Yeah, maybe middle of summer even.
Yeah.
It's hard to guess there.
Okay, all right. Everything else runs smooth, I guess.
Fairly well.
No news is good news, so appreciate it. Take care of yourself. Don't fall down.
Thank you.
All right. April, do you have anything for us?
Nothing this morning, thank you.
Kyra?
No.
Mr. Abbott, you have anything?
No, I don't believe so.
Preston, you have anything?
No.
Tony?
Just on this subdivision control, if anybody's got any concern or anything, I'm open to talk to people, because I got a few myself, and hopefully we can work through them. They're minor and get them took care of, but I think there needs to be a few changes.
Yeah, we just need to figure out what they are and make sure you understand what it says,
A
so.
lot of it's in the wording, so couple items personally that affects what my intentions down the road is with my farm, so
Okay. Entertain a motion to adjourn.
I make that motion.
I'll second that. Everyone in favor, say aye.
Aye.
This thing